How many students have had Professor Reed? Okay, because I work with her husband, Jake Payne, and I've always thought it would be cool to have everyone say around, I have to go to class with Professor Payne. But she doesn't use that. I don't know why.
Just that reason.
Okay. Anyway, aside from that, I had a question just so I can gauge the audience. How many people here are actual practitioners versus students? Okay, so I have okay, and how many people have taken patent law? Just so we see where we are. Okay, it's a small handful. All right, well, I guess this is what happens when they call you last with the available topics to talk about in a symposium. But hopefully everybody's taken civil procedure because we are going to get into the bowels of it. A lot of these cases that we're going to talk about are litigators' dreams, litigating for 4 non-stop years and not a chance of ever reaching the merits on a case. But that's what these things are, and they're significant issues. They're not taught in law school, and they're hot enough that there's probably been a Supreme Court. It's gone to the Supreme Court yearly on different aspects of it. And so with that, we'll get into it. We're going to talk about, and a lot of these come up, as you can imagine, in litigation in the context of licensees who are in an agreement with the patent owner, and they have a dispute, and so who can bring what claims and where and how. And so we're going to talk about the ability of a licensee to have standing to bring a lawsuit against the licensor. If a licensee doesn't want to wait to get sued, and so they want to get an answer ahead of time, they would bring a declaratory judgment action of non-infringement, so that way you can hopefully get an opinion without having to violate someone's rights in advance. And the Supreme Court recently came out with a decision affecting that. And then we're going to talk about jurisdiction and counterclaims. And there were some cracks in the rules where patent cases could hypothetically or could end up in state court. And so we're going to talk about all those issues, and some of them were cleaned up by the America Invents Acts. But the first issue we're going to talk about is licensee standing, and this was a Supreme Court case from 2007, Medimune versus Genentech. And it had a really, at least to me, it had a really interesting fact pattern. Genentech owned technology called K-Billy or K-Billy, and there was 2 different forms of it, and they referred to it as 1 and 2, at least in the litigation, to simplify it for the judge. And Medimune was the licensee, and this was a very valuable drugs. And the deal was that once these patents issued, royalties would be owed, and the K-Billy 1 patent issued, and so Medimune paid the royalties on it. But there was an interesting prosecution history in the patent office with respect to the K-Billy 2 patent. And what actually happened was that while the application for Genentech for it was pending, somebody else, another company, Celtech, had filed an application that covered the same invention. And the patent office will only issue 1 patent per invention. So the patent office, and fortunately they caught it, because sometimes they don't, and the patents actually issued 2 patents for the same invention. And so the patent office has an internal proceeding where they have to decide who is the first inventor. And it's a winner-take-all. Only 1 patent's going to issue, and it's going to only go to 1 of the 2 applicants. And so in this situation, and as you can imagine, Medimune wants to monitor this closely if they could, not Genentech, not their licensor, but the other company, Celtech, actually won the interference, and the patent office declared them the first inventor. So Genentech is not going to get their patent. So what Genentech did, like all good firms who don't like a result, they appealed, and they ended up taking it to the district court, because if you don't like the patent office's decision, you can appeal it through the administrative process and ultimately have a court give it an independent review on appeal. And at the district court level, because that's where the appeal went, Celtech and Genentech, Genentech and Celtech settled the case. And as a result of the settlement, it would seem that Celtech rolled over and says, okay, Genentech, you're the winner. District court orders the patent office to issue the patent to Genentech. So now they have their patent on the K-Billy 2 technology, and they go back to Medimune and say, now you got to start paying royalties on this. And they're going to say, well, wait a minute, you know, the patent office had a full hearing on the merits, you presented your evidence and you lost, and you have a paper settlement where you got the winner to roll over and agree that black is white and white is black. So I'm not so sure that we want to pay royalties on this. And so as you can imagine, and this is the practical situation, MedImmune goes to their lawyers and says, what do we do? And it's like, well, you could, option A is don't pay royalties on the K-Billy 2 patent if you think it's invalid, because we could litigate it, take all the evidence that the patent office had, and you might prevail just the same, because Celtech already presented the case and was able to convince someone. And they're like, well, but the risk of doing that is what happens if you lose? Then not only are you an infringer, but you've lost your license because you've stopped paying royalties. And and if they had terminated that agreement, they probably would have also lost their license to the K-Billy 1. So, okay, why don't we take something that's a little safer, and let's file a declaratory judgment action to declare whether this K-Billy 2 patent is valid or not. And we have this evidence from this other proceeding. But for a long time, there was a long-standing, the case law had held, if you are a licensee in good standing, under the license agreement, you don't have standing under Article 3 of the Constitution to bring a declaratory judgment action, because there's no threat of an infringement action being brought against you by the licensor. So you were stuck, and there wasn't anything you could do. And so in 2007, the Supreme Court revisited this long-standing decision of the Federal Circuit that a licensee who's paying royalties, is not in breach, can't challenge the patents that he's licensed. And so the Federal Circuit had stood by this, but the Supreme Court in an 8-to-1 decision reversed, saying no, a licensee in good standing has the right to challenge the patent. And they cite to the Declaratory Judgment Act, where you have to have a case of actual controversy. You can go to courts to have your rights declared and other legal relationships determined. And as you remember from con law, Article 3 requires case or controversy, have to have a definite and concrete dispute, real and substantial, no advisory opinions. And the issue here was, well, if you're not at risk of being sued, then isn't this just an advisory opinion, or where is the controversy? And that was why the precedent had been, you cannot bring suit if you're a licensee in good standing, because you're not under any risk of being sued for infringement. But nevertheless, the court here looked to precedent from other declaratory judgment actions and said, this seems to fit the same set of circumstances. If there's a law, a criminal statute, and you're in fear of breaking it and you want to challenge it, you don't have to break the law, risk going to jail to bring that challenge to a statute. And so following that and following insurance contracts and the other guidance, the court said that Article 3's case or controversy requirement can be satisfied by the fact that the licensee faces the threat of suit if it stops making the royalty payments. And now Clarence Thomas dissented, saying this is still too hypothetical, but nevertheless, so this opened up the door for licensees now, even though they're in good standing, not going to terminate their license agreement in fear of breach, can be in the same position as anybody else to challenge the patent. Then the more recent case, and this is the hottest, latest topic, is the burden of proving infringement in declaratory judgment actions. So now that the door's been opened for the licensee to bring that challenge, earlier this year in Medtronic versus Mirowski family, we came up with another interesting issue. Ordinarily, it's the patent owner who brings the suit for patent infringement. In bringing it, the patent owner carries the burden of proof and persuasion to show that what the accused infringer is doing, that their product or activities fall within the claims of the patent. And a declaratory judgment action is the mirror image of that patent owner's enforcement action. And it's the accused infringer bringing a suit saying, look, I'm concerned about infringing the patent. There's a controversy here. Maybe he sent me a cease and desist letter. So I'm going to file suit first, and I want the court to declare or resolve this issue as to whether my activities are infringing the patent. And the law has typically been, well, who carries the burden of proof? Because technically the licensee or the accused infringer is the actual plaintiff in the suit, because they're the one that filed the suit, and they're in the position of the plaintiff, and they're asking the court, so should they have the burden of proof to show that they're not infringing? And the law had quite often held that it's the patentee who carries that burden. And so this case just went to the Supreme Court, although this is more on the specific issue of the context of a licensee bringing the declaratory judgment action. This would not apply in the context of someone who gets a cease and desist letter, so they file first. Maybe they're fighting over where the suit's going to be brought, but this is in the context of a licensee. And here we had a family trust that owned a number of patents on implantable heart stimulator, and that was the claimed patented technology. Medtronic was a licensee of that technology. And Medtronic, the licensee, filed a declaratory judgment action, and they wanted to have it declared that they did not have to pay royalties on certain products that they were selling because they believed they did not fall within the claims of the patents they licensed, so they shouldn't owe royalties on it. Now, so they asserted they're not covered by the patent, and therefore they don't have to pay any compensation to the patent owner under the contract. Now, the unique thing here, following the guidance of MedImmune, was Medtronic was a licensee in good standing. They continued to pay royalties, and their license agreement contemplated the situation. And look, I don't want to fund your litigation while we're in this, so I don't want to pay you the royalties. So they had an agreement in the license where they would put it in escrow, and it would sit in an account, and the winner takes all. And that's a very common provision, been around a long time. And Medtronic was not in breach of the license. They just wanted to know whether they owed it or not. If we owe it, we'll pay it. If not, then we'll get to keep it. And here, the district court sided with the licensee, with the issue being, okay, when this case goes to trial, who's going to carry the burden of proof? Is the patent owner going to have to prove that I infringe? Or is it the licensee who's going to have to prove I'm not infringing? And I guess if you look at it, I mean, hypothetically, or maybe practically speaking, this lawsuit was filed. Look, you're the plaintiff, you're the licensee, you say you're not infringing, so you should carry the burden of showing how you don't infringe. I'm not the one who asserted this. I should sit back, hear your case, see if you prove it, and you're the plaintiff. The district court sided with the licensee, saying, yes, you brought the suit, but it's the patentee who has to carry the burden of persuasion and proof and show that you're an infringer. And they're sitting there scratching their heads, but we just want the royalty. We didn't threaten the lawsuit. And the Federal Circuit, following its long precedent, said, look, it's the patentee who has to carry the burden of proof. And here, the Supreme Court, in a unanimous decision, when a licensee seeks a declaratory judgment against a patentee to establish there's no infringement, therefore no royalties owed, the burden of proving infringement, it will stay with the patentee. And so the patentee always carries the burden even though he's the defendant. Why is this significant, or I guess what were the rationale? The patentee always carries the burden anyway. The Declaratory Judgment Act is procedural. The underlying infringement claim is the substance of it, and the burden of proof is a substantive issue. The policy issues, which probably drove the case really even more, the patent holder, or practically speaking, the patent holder is in the better position than the alleged infringer to know how and point out the who, what, where, why, how as to why royalties are owed. Because as you'll find out in practice, patents have many claims, and they're big, they're confusing, and to put the burden on the licensee to have to concoct every possible theory of infringement and then disprove it and attack every single claim it's pretty impractical and unrealistic. And so when the patent owner brings the suit for infringement, they'll typically, through discovery, and they'll have to identify the claims they're asserting and the products that are infringing. So we want to keep the case more simple instead of having to prove the negative. Some of the policy considerations behind the case, and you'll see this throughout the history of the courts and how they make a lot of the decisions in patent cases, is that they want patents to be open to challenge, they want a well-balanced patent system, and they want invalid patents and these types of issues adjudicated at the earliest possible dates. And licensees are often the only individuals, they usually have the most knowledge, and they also have usually the most economic incentive to litigate these questions. So they've eased that burden on the licensee and put it back onto the patent owner. But it's an interesting case because it leaves open a lot of unanswered questions as to, I mean, well, we know who's going to carry the burden, but how is this going to affect licensing and contracts in the future? And I guess some questions is, with this case, with the benefit of hindsight, are people going to try and address this in their license agreements? If anybody was thinking of writing an article, any of the students, this is a good hot topic. Could the patent owner, when they negotiate the license, can he require the licensee to agree that they won't bring a declaratory judgment action for non-infringement? Meaning, can you contract away or waive the right to this type of a challenge, or would that be unenforceable on some public policy ground? Just as an example, a clause in the license agreement that says you agree by paying royalties and agreeing to these terms, you will never challenge the patent on grounds that it's invalid. That is black letter law since the 60s. Supreme Court ruled in Lear versus Atkins, you cannot, there is no licensee estoppel on the grounds of invalidity. And in fact, if you have that clause in your license agreement, you run the risk of it being held to be a patent misuse and being unable to enforce your patent for abusing your limited monopoly rights. So we know you can't make a license, force a licensee to agree not to challenge on validity grounds, but can you have them agree not to challenge on non-infringement? That's an open question. What if the license agreement says that the licensee agrees that he'll carry the burden of proof in the event of a declaratory judgment action? I haven't seen any cases on that. There's been discussion of that. I don't think that's very practical. I don't think a court is going to let a contract provision change substantive and law and how cases are tried. I kind of look at it the same concept of, you'll see agreements where there's the injunctive relief clause and you acknowledge you'll be irreparably harmed and there's no adequate remedy at law, and those are jurisdictional or requirements. Most courts won't take that on their face, and I could see that falling the same way. Now, it's influential, but the court can still make its own decision. Some other thoughts, and this is the more practical, because now we're not chilling rights and we're not taking rights away. What if we had in the license agreement, if you're the licensor, well, I probably can't take away and have a no challenge clause because that seems really unreasonable. What if I say, look, if you want to litigate against me over infringement and these issues, the royalty rate doubles. So you have a financial disincentive in the agreement. Can you do that? Will that happen? I know there's been talk. I'm not aware of any cases saying you can't. What about a right to terminate? In the event of litigation, licensor has the right to terminate the contract, so you can threaten to pull the rug out and end it. Or, maybe this one seems more practical, if the licensee challenges, we're going to suspend the agreement. And so the licensee has to stop during the period. But these are all unanswered questions, hypotheticals. Time will tell what happens here. But one thing that the court did not consider, and it's probably because under the facts of the case, it did not come up. The facts were simplified, but what really had happened was that Medtronic had a license agreement, and it had a provision saying, look, you may sell products in the future that may fall under the license, and if we discover something along those lines or we get more patents, then we'll contact you, we'll advise you, and then you'll owe us royalties. And it came up in the context of that, where it was a new product Medtronic was selling, and they simply disagreed that royalties would be owing for that product. It's not the traditional case where you've been selling things under a license agreement for years and decide overnight, hey, maybe I don't owe these royalties because it doesn't infringe. That's the more common situation than what happened in Medtronic. But there's a doctrine out there not everybody is aware of, and it's called patent marking estoppel. And the concept of it is that if an infringer or a licensee puts the patent number on a product that they manufactured and sold, then they are stopped from denying that the product embodies the patent. So, for example, in the context of counterfeit goods, somebody
just flat out copies the product all the way down to the patent notice on it where it puts the patent number, that stops them in litigation from arguing it doesn't infringe because they took the benefit and claimed it was covered by the patent when they were out there selling it. And at least the Second Circuit in a number of cases has said that doctrine of patent marking estoppel would apply to licensees as well. It's that you're stopped for purposes of liability for both patent infringement damages and patent license royalties. So maybe having that clause, and this one is standard and it makes a lot of sense, it protects everybody. Licensees have to mark their products with the patent number and satisfy the marking requirements, because you have to do that to seek damages in patent litigation anyway, because failure to mark, the statute says you don't get damages if you don't mark. So arguably, if the licensee's been selling the product and he's been marking it with the patent number, maybe you can raise this, seek dismissal early in the case, claiming, look, he's stopped from denying infringement because he marked the products with my patent number. So that hasn't been answered. That'll probably come up more in the future. One other thought, I don't think this one's practical because it's not going to change the way people structure compensation, and you can only front load license agreements so much, because as money comes in, money goes out and goes back to the licensor. But I guess one question that has arisen in the past is, well, what happens if I have a license agreement, I have the same situation, I've been paying royalties for 10 years, and I discover, maybe this product isn't infringing this patent. I don't want to pay anymore, or I discover some prior art that the patent is invalid. And I go to court and I have the patent adjudicated invalid. Can I get a refund of all the royalties I've paid over the years? Because it was just a big mistake, right? I never really owed them. I was paying royalties on an invalid patent or a patent I didn't infringe. And the case law on this is fairly clear, and the answer is no, you don't get that back, because the benefit of the bargain, patents have a chilling effect. As long as they're out there and they haven't been challenged, it chills competitors, you got an advantage, and so you are not going to, you're going to be obligated to pay royalties until you take affirmative steps to disavow the patent. And that's either to give the licensor notice or bring a lawsuit challenging the patent. But anything paid prior to that challenge is non-refundable. So maybe if you, that's something to think about, but I don't think I don't think people are going to change the way they do business with that. One other interesting debate, and this was, I'm not going to take credit for this thought, and the same thing happened with MedImmune, and it's maybe licensees shouldn't have the right to challenge the patents that they've licensed under agreements, and maybe they should carry the burden of proof, because when they entered into the license agreement, they presumably either did or had the opportunity to do the due diligence. And they knew that an alternative to paying the royalty at the time they entered into the license was to ignore the patent or challenge the patent. And so weren't they buying peace and entering into a license agreement so they wouldn't have to litigate? And when they negotiated that royalty rate, they paid based upon their opinion of how strong or valuable the patent was. So this waiver of future litigation and not challenging, that arguably factored into the negotiation in what you took as the royalty rate. So let the parties enter into contracts and let them decide for themselves whether they're getting enough value that they want to give up that right. And so let the market dictate and take it away. So maybe you don't feel so bad for the licensee anymore, but it doesn't really it still undercuts that underlying policy. We want anybody with an interest, especially those with the greatest interest, to go to court and seek to adjudicate patents invalid when they are. All right, now here's the one that I've always found interesting, and I've only had to come up really once in my practice, and it really wasn't in the context of the counterclaim jurisdiction, but it's the context of who has jurisdiction over patent disputes, both in the trial court level and at the appellate level. And this came up in 2002, and it's still important now because this case from the Supreme Court left a gaping hole or a loophole in how to have your patent case potentially heard in state court, or how to have your appeal heard not by the federal circuit. And I guess let me start with a little bit of primer here. Patent law, they're federal statutes, and the law provides that cases for patent infringement and claims arising under the Patent Act have to be brought in federal court. If you bring it in state court, they lack subject matter jurisdiction. And unlike just about every other type of federal claim you have, where Florida sits in the 11th Circuit with Georgia and Alabama, if you file suit in a federal court here and you're on appeal, it goes to the 11th Circuit. However, in the early 80s, Congress decided that we needed better uniformity in the world of patents, and so all appeals from cases arising under the Patent Act will bypass the regional circuit and go straight to the United States Court of Appeals for the Federal Circuit, which is, it's a special circuit court. It's an appellate court, and they are the only court, presumably, that hears appeals in patent cases. If you're doing research, you don't have to worry about splits in the circuits. You only have to search the Federal Circuit, because that's where all the cases come out of. And it's fun if you're ever in D.C. The courts, it's catty corner to the White House, and if you can get in, and actually only about, I think it was 40% or so of their appeals are actually in patents. They have a technical advisor on staff to help them. And there's always debate. They have the highest reversal rate of, I think, all the circuits. The Supreme Court constantly reverses them. The Supreme Court does not think patents are any special, that they're deserving of special rules. And the Federal Circuit, in all the cases I have here, they got reversed. And it's a common trend. I think the Chief Judge of the 8th Circuit in a conference less than a year ago already is talking about doing away with the special patent court because he doesn't think that it's been successful. It always comes up. I don't think it'll happen, but nevertheless. So the question here is, the way this, let me jump to the facts of the case, and it's a real fascinating one, at least to me, and it's got a lot of background. But there was a company called Varnadoe, and they were in the fan and grill industry. I mean, like the industrial type fans, I'm assuming. And they had a patent that covered their grill design for a fan, and that patent had expired. And so to, I guess, resurrect or continue and extend their exclusive rights, they claimed that grill design as their trade dress. And they sued people for trade dress infringement, even though their patent had expired. And in their first case back in '95, they sued a company called Duracraft. And they sued them in the 10th Circuit. And the 10th Circuit said, well, wait a minute, we have a per se rule that they adopted in that case. If a product configuration is covered by a utility patent, then it can't receive trade dress protection because it's functional. And so they had a per se rule, unprotectable. However, the Federal Circuit wasn't so rigid in their analysis, and in an unrelated case, facing the same issue, they said that trade dress protection is not foreclosed to the extent that that design had non-functional elements. So here you have one circuit saying per se unpatentable, and another circuit, and again, this is trademarks, not patents, thus no unique appellate jurisdiction, and you can have splits in the circuit. So Varnadoe sued Holmes Group was threatened with this claim, and they were in much litigation with Varnadoe, and so Holmes filed a declaratory judgment action, and again, this is forum shopping. Okay, we know that we're being threatened by Varnadoe. They're not willing to accept that they don't have trade dress protection. Perhaps the Federal Circuit resurrected their dead trade dress with this hope that maybe there's no per se rule. So realizing they had facing this threat of trade dress litigation, they went straight to the 10th Circuit where they knew that it had already been adjudicated unenforceable, and they filed suit in Kansas, have a declaratory judgment that the trade dress was not infringed, and they would assert collateral estoppel. Same trade dress, already litigated in Varnadoe's Duracraft case. 10th Circuit held unenforceable. I think, looking at this, I'm sure the associate doing underlying research said, hey boss, I think we can win this one. Because we can file in the 10th Circuit, which has already analyzed this trade dress and held it invalid. So that's what they did. So they filed this declaratory judgment action, and Varnadoe counterclaimed for patent infringement of a different patent that they had. So the Kansas court rules in favor of the Holmes Group. Trade dress was already held invalid. And so Varnadoe, they appealed the case to the Federal Circuit because that's the forum that they liked. And so the question is, well, we're sitting in Kansas. Kansas is in the 10th Circuit. How does this case get to the Federal Circuit? And well, Varnadoe's position was, well, wait a minute, I brought a counterclaim for patent infringement, and we know all patent appeals are heard in the Federal Circuit, and so it just so happens that their law isn't going to apply the Duracraft ruling, and I may have my trade dress resurrected. And Holmes Group says, no, this case belongs in the 10th Circuit because we brought the case in Kansas, and our claim wasn't involving patents, it was involving trade dress, which goes to the regional circuit. And so this case made it to the Supreme Court because trying to decide who has appellate jurisdiction over this case. Now, traditionally, if the original complaint that was filed has a patent infringement claim, automatically goes to the Federal Circuit. But the underlying claim did not have an infringement action. It was strictly trade dress, regional circuit law. So can a counterclaim make it, or change that outcome? And 28 U.S.C. 1295A1 is the statute that says the Federal Circuit has exclusive jurisdiction on appeals from a district court in a civil action arising under any act of Congress relating to patents. And 1338A is the counterpart which gives the district court, the trial court, that jurisdiction over civil actions arising under patents. And so the Supreme Court applied what's known as the well-pleaded complaint rule. The plaintiff is the master of the complaint. They decide the forum, they decide the issues. And so unless looking within the four corners of the complaint, there is a claim that arises, or the case arises under the patent laws, and the Federal Circuit is not going to have jurisdiction. And here they said the four corners of the complaint is strictly for trade dress. There's no patent issues. So the Federal Circuit does not have jurisdiction. It does go to the 10th Circuit. And so what happened as a result of this meant that if the initial complaint that's filed doesn't arise under the Patent Act, and there's a counterclaim for patent infringement, we're now going to have regional circuits, 11th Circuit, 10th Circuit, now deciding patent cases, and we've lost the uniformity. But that was the law, and maybe that was just the way the statute was drafted, and it's an unintended consequence. And even crazier than this is, what if that trade dress claim had been brought in state court, and nobody removed it to federal court? Because trademark, trade dress, those claims can be brought either in state or federal court. You could have a patent infringement counterclaim, arguably, that was in state court now. Because the arising under, it doesn't arise under, it's in the counterclaim. And so this was a concern. Now the 8th Circuit, a case under these circumstances, post-Holmes Group, reached the 8th Circuit, and realizing that they don't want to get in the patent business, said, we're just going to do what the Federal Circuit does. And so we're going to follow their line of precedent rather than our own. And that's how they resolved it. So anyway, the America Invents Act, they have included the Holmes Group fix. And some of it's a little counterintuitive to what is traditionally concepts of procedure, but it clarifies that the state courts don't have jurisdiction ever over patent and copyright claims. It extends the Federal Circuit's appellate jurisdiction to counterclaims that are compulsory, and it changes the removal statute, which I'll talk about in a second. And here's the amendment, and what they added was, no state court shall have jurisdiction over any claim for relief arising under any act of Congress relating to patents, plant variety protection, or copyrights. So where before it didn't say that, now the bottom line is, if there's a claim brought in state court, whether it's a counterclaim, permissive, the bottom line is the state court can't hear it. So at least they've gotten it out of state court in that regard. Now on the appellate, they've said, now the Federal Circuit, in addition to having jurisdiction over a civil action arising under an act of Congress relating to patents, they've added or which a party has asserted a compulsory counterclaim. So now that is the fix for the Holmes Group case. And here's the one that's a little shocking, and I guess again, this is to get things out of state court. Ordinarily, the removal statute, and this is if there's a case brought in state court where a federal court also has jurisdiction, a defendant, if he can meet the requirements for having the case heard in federal court, which whether it's diversity or it's a federal statute, the defendant or another party can remove the case, or the defendant can. And so now what they have is any party asserting relief may remove the case if it arises, if it relates to patent. So you can have a plaintiff bring a case in state court, which could happen, say it was for trade secret or trade dress protection, not trade secret. That's always state court unless there's diversity. But brings a trademark action, which is either. And the defendant decides, I'm not going to remove it. I'm the only one who traditionally has the ability to move it to federal court. Chooses not to and brings their counterclaim for patent infringement, although I guess now they can't. But this would allow the plaintiff, after the defendant files his counterclaim, to remove the case to federal court. So here you have a situation where a plaintiff who chose the forum and chose state court now has the power to remove a case to federal court. And I guess what's the federal court going to do? I guess it's going to make the decision as to, well, I guess they're going to hear it and get it out of the state court, who arguably couldn't hear it anyway. So that's the Holmes Group and how the AIA finally fixed that. Last issue I wanted to talk about, and this is a case, I believe from the last term, is every now and then you'll have a situation where a case involves issues of patent law, but it doesn't necessarily fall within federal court jurisdiction. And I guess an example that the one I had come up in practice is there was a breach of a license agreement where the licensee was accused of underpaying royalties. And his defense, and so the claim is breach of contract. Where are contract claims heard? Traditionally in state court. And that's where the action had been filed. And so we were brought in late in the case, and we're looking at the contract representing the licensee. And it's like, well, you know, and the question was, well, do we owe the royalties? And you look at the contract, and it's like, well, what does it say? It says, royalties are owed for all products that are covered by the patent. And it's like, okay, so how are we going to show whether the product is covered by the patent? We're going to have to do the entire patent infringement analysis to see whether these products would have infringed the patent. And so by doing that, we're going to have a claim construction, and then we're going to have the claims interpreted, and we're going to have to see whether those claims, as they've been construed by the court, whether there's the corresponding elements found, each of those elements can be found in the accused product. So now we're in state court, and are we going to be asking a state court judge to do the claim construction and have a Markman hearing and apply patent law? Or should this be brought, is this more properly suited for federal court? And so that's been the dilemma, and you'd be surprised, but a lot of those cases stay in state court because it's unclear. Well, here's one that came up in more of an unfortunate situation. State law claims that require some interpretation of patent law. And in Gunn versus Minton, Gunn was an attorney, and Minton was his former client. And Gunn represented Minton, who sued somebody for patent infringement. So Minton was a patent owner suing for patent infringement, represented by Gunn. And not only did Minton lose the case, finding there was no infringement, his patent was held invalid due to the product being subject to the on-sale bar. And as we heard from the last speaker about all the prior art, to some degree, if the product was on sale more than a year prior to filing the application, you're not entitled to a patent. And in this case, the court concluded that the on-sale bar applied and Minton's claimed invention had been on sale. So he lost not just the case, he lost his patent. So he turns around and he blames his attorney for that. And so he brings a case in Texas state court asserting malpractice against the attorney for losing the case. And what was the argument? His argument was, yes, maybe the product had been on sale more than a year, but there's an exception to the on-sale bar known as the experimental use defense. Look, I had to test my product, and the only way to test it was to sell a few and see how it worked. It's a legitimate defense, and it goes back. The landmark case on this involved, there was one of the first paved roads. They wanted to test a paved highway, and so They put it out there in the public so that people could ride over it, and they had a toll booth, and they collected tolls. And they claimed that the on-sale bar applied, and the court there said no, they had to test it. The only practical way was to have cars go over it, and the fact that they charged the fee to use it didn't change the result. You have the experimental use defense. And so that's what it is. But here, at trial, Minton lost the malpractice case because the trial court agreed with Gunn and granted summary judgment in that attorney's favor, saying that the patentee, he offered less than a scintilla of proof that any use he had made was experimental. So yes, maybe the attorney didn't raise the experimental use defense, but the trial judge wasn't convinced that it applied either. And so as you can see here now, you have a state court judge in a state court action applying concepts of on-sale bars and applying the concepts of experimental use and whether a use was sufficient to constitute an experimental use. These are all questions, significant questions of patent law that Congress has decided should be heard by federal judges only and heard in appeal to the Federal Circuit. So after Minton brought this suit against his attorney and lost, realizing that his suit had come to an end, he does, I guess, the next best thing, and he changed tactics. And now he appealed, saying, remember that suit I brought in state court that I lost and I had tried and we spent years litigating? Well, my mistake, I was supposed to have brought it in federal court because the state court lacked subject matter jurisdiction because it arose under the Patent Act. And so he wanted the fact that him as the plaintiff in the case he brought, he wanted it all dismissed so that he could try again and bring the case in federal court after the fact. And so the question that arose, and the Federal Circuit for years had held in cases that made it to the Federal Circuit, patent malpractice cases raise that substantial question. They arise under the Patent Act, and the jurisdiction is proper in the federal courts. But here's one that never made it there. The first challenge was brought then. The Texas Supreme Court agreed with Minton and reversed the decision and was going to let him start over in federal court. The case goes to the Supreme Court, and they unanimously reverse. And again, reversing a long line of Federal Circuit opinions saying patent malpractice cases are better brought in federal court. And it's kind of an interesting analysis, but in order to invoke this exclusive federal jurisdiction, there's two ways that it can arise. One is if the Patent Act itself creates the cause of action. So a case for patent infringement is a lawsuit that arises specifically under the Patent Act, has to be brought in federal court. But what about state law claims that aren't under the Patent Act, but how do they ever arise under it, such as this malpractice case? And the Supreme Court applies four considerations that apply. Is the federal patent law necessarily raised by the claim? Is it actually disputed? Is it substantial? And is it capable of resolution in federal court without disrupting the federal-state balance? The parties conceded that the first two elements had been met, that there was an actual dispute over the on-sale bar, and that it necessarily raised the claim of having to decide that issue. But where the Supreme Court differed was they looked at that substantiality problem, which was number 3. Was it a substantial issue? And here the court concluded they look at the importance with respect to the patent system as a whole, not how substantial it is to the parties. And what they pointed out is this really isn't that substantial because it does not affect the patents in any way. The patent has already been held invalid in that prior litigation. So what we're really litigating here is a hypothetical situation. The patent's invalid, it's lost. Hypothetically, this case is only about whether the attorney committed malpractice. But the patent, and what damages you can recover for the patent being held invalid because of his arguable mistake, if it was one. So we're really deciding hypothetically what would have happened if he had asserted that defense, but it's not going to change the outcome with respect to the patent. And they like to use the language that it was really a case within a case, where the patent issues were a case within the malpractice case. Any decision of that state court would not be binding precedent on the federal courts with respect to the patents or any future patent litigation. And there really was no substantial importance to the federal patent system, and to the contrary, the state has a very well-established interest in regulating the practice of law. And so for those reasons, the Supreme Court held that a malpractice case that involves issues of patent law, that requires a state court judge to interpret them, that's okay, that's going to stay in state court.